Before we begin, this video provides general educational information only. It does not constitute legal advice, and watching this video or contacting the firm does not create an attorney-client relationship. I am Dr. Belinda Gail Quarterman Noah, attorney at law, of the Law Office of Dr. Belinda Noah and a member of the Florida Bar Admiralty Law Committee. When you leave dry land, you leave behind the normal rules of geographic law. Many believe that if they are on a private boat trip with friends, or if a vessel begins malfunctioning or taking on water, normal land-based negligence principles immediately apply. But the moment your hull touches navigable water, you enter the realm of admiralty and maritime law. It is a complex web of invisible, centuries-old statutes, federal jurisdiction, and unique duties of care. If something goes wrong out on the open water, who is legally responsible? The person steering? The person who bought the boat? Or does the water wash away liability entirely? Public confusion surrounding maritime responsibility often peaks during tragic watercraft incidents, such as the widely discussed July 2026 events involving a boat trip to Horns Island off the Mississippi coast. Before diving into the legal mechanics, I want to extend my deepest, heartfelt condolences to the family of Nolan Wells, and to all families who have endured the shattering pain of a tragedy at sea or anywhere. It is out of respect for these profound losses that we must clarify these invisible rules, so that boaters are better equipped to protect themselves and their loved ones. This tragedy has highlighted an immense legal blind spot. In that developing matter, public attention focused heavily on distress calls, bilge pump malfunctions, and the tracking of the boat's movements via GPS data. This tragedy has highlighted an immense legal blind spot for everyday boaters: the profound confusion regarding the separate legal liabilities of boat owners versus boat operators. If a boat is lent to a group of friends and suffers a critical mechanical failure, the law immediately splits its gaze. Under maritime principles, a boat owner may be held liable for providing an unseaworthy vessel, or for negligent entrustment if they knew the boat was unfit. Conversely, the operator at the helm possesses an independent legal duty for the safe navigation of the craft and the safety of everyone aboard. The water does not mask accountability, it multiplies it. Liability can fall on both the owner and the operator depending on the circumstances. The first invisible layer is admiralty jurisdiction. Under the United States Constitution, legal disputes occurring on navigable waters are governed by federal maritime law. What makes this an invisible trap? First, the standard for what constitutes a navigable water is deceptively broad, including any body of water that can be used for interstate commerce or travel. Second, maritime law introduces doctrines like the Limitation of Liability Act. This staggering, centuries-old statute allows a vessel owner to petition a federal court to limit their total financial liability. Liability can be limited to the post-accident value of the boat itself, provided the owner lacked knowledge or privity of the negligence. It is a powerful federal maritime injunction. The second invisible law governs those who work upon the waves. Seafarer rights, anchored primarily by a federal statute known as the Jones Act. While land-based workers are restricted to workers' comp, the Jones Act provides seamen injured due to employer negligence the explicit right to bring a lawsuit and demand a trial by jury. To qualify, a person must be a seaman, meaning they contribute to the function of a vessel on navigable waters and have a connection to it that is substantial in both duration and nature. Furthermore, general maritime law guarantees seamen maintenance and cure, an absolute right to food, lodging, and medical care through their recovery, regardless of who caused the injury. The third invisible framework governs the ultimate tragedy: maritime wrongful death. Many assume a standard state suit applies, but the law draws an invisible line, precisely 3 nautical miles from shore. Inside that 3-mile boundary, state statutes generally apply, but crossing into the high seas brings the Death on the High Seas Act, or DOHSA, into exclusive control. DOHSA is a strict, invisible trap. It explicitly limits recovery to pecuniary damages only, meaning proven, quantifiable financial losses like lost wages or burial expenses. Under DOHSA, a grieving family is barred from recovering compensation for their intense emotional pain, suffering, or loss of companionship. Where the death occurs changes everything. The fourth invisible law catches those who purchase a watercraft together. If a boat is owned 50-50 and one partner takes it out and commits gross negligence, can the absent co-owner be sued? Under maritime law, joint ownership can trigger the doctrine of vicarious liability if the boat was being operated for a joint enterprise or shared business purpose. Shared ownership means sharing exposure. If the boat had a pre-existing mechanical defect, like a faulty bilge pump system that both co-owners failed to maintain, both can be held directly liable for providing an unseaworthy vessel. Where many fall into an invisible trap is failing to recognize how the framework shifts. If money changes hands, even just splitting fuel costs, a private vessel may transform into a commercial charter. Once it becomes an uninspected passenger vessel, licensing requirements skyrocket, and liability exposure expands exponentially. The law expects the standard of care of a prudent mariner. Suppose an emergency occurs. The hull is taking on water or a passenger is missing. Do not freeze. In maritime investigations, your distress calls and GPS logs are critical legal evidence. Federal agencies like the U.S. Coast Guard and the FBI regularly audit digital data and radio frequencies. An impulsive or delayed response can drastically compound civil and criminal liability. Here are several practical steps. Ensure bilge pumps and safety gear are fully inspected before leaving port. Formally document owner and operator roles in writing. Review your marine insurance. Standard homeowners coverage will not protect you from federal admiralty claims. And if an incident occurs, preserve all GPS plotters and maintenance logs immediately. Consider promptly consulting a qualified attorney when an accident occurs on navigable waters, or if you are a maritime worker facing resistance over your Jones Act or maintenance and cure right. This is Dr. Belinda Gail Quarterman, NOAA, attorney. Thank you.